Muy buenas tardes.
A very fine afternoon to one and all. We will now begin our meeting 2171. I am very pleased again to receive the delegation of Cameroon, led by Ambassador Salomon Ehid. We can thus continue to consider the sixth periodic report from Cameroon in this 2161st meeting. Ambassador, you have the floor.
Muchas gracias, señor.
Thank you very much, Mr. Chairman. I will continue in French, with your leave. Thank you very much, Mr. Chairman, and good afternoon to the honorable members of the committee and to all of those who are here in this room. Mr. Chairman, distinguished members of the committee, ladies and gentlemen, in this important session of the CAT, again, this is more or less the concluding session in considering the sixth periodic report of our country. So some introductory remarks here. Cameroon, as everyone knows, Cameroon is a state with rule of law. It is and I see that in all senses of the word, it is a democratic state. The head of state, Mr. Paul Biya, since ascending through the supreme magistrate of the country, has made human dignity and human rights a central pillar of his leadership. The law on liberty and freedom, voted in 1990, clearly set forth his vision for his field of action, setting his firm commitment to the development of human rights in Cameroon. There is no torture at the hands of the state in Cameroon. The state of Cameroon does not practice torture. There can be cases of torture that are not committed at the hands of the state. The pause, the moratorium on the death penalty, is an eloquent statement reflecting the efforts of the Cameroon state to fight violence in all of its forms. When there are violations of the law, the jurisdictions are there to prosecute. Mr. Chairman, the case of torture that will be addressed here are not acts committed by the state. These are isolated acts of people not authorized by the state. And as I had indicated, inquiries were launched immediately to ensure accountability. The state of Cameroon has never ordered anyone at all to practice torture. The President of the Republic has enshrined fundamental liberties, freedom of speech, freedom of association, freedom of circulation of individuals, etc. These are realities in Cameroon. For those who travel or look at social media, they bear witness to this. The chairman, Cameroon today has more than 350 political parties. There are more than 300 different media outlets, television, newspaper, written press. No one has to hide to speak in Cameroon. The President of the Republic has indicated on repeated occasions that no one should be investigated as a result of their opinions, and that is important. Now, the person who has been most criticized in Cameroon is the president. When we look at at social media, one would ask if he was sensitive to this. I'm going to stop there. I don't want to make comparisons. One has only to visit the internet to see what is written about Cameroon and the President of the Republic every single day. That to reaffirm that there is no state-sponsored or ordered torture in Cameroon. People are free to express themselves, and when these freedoms are abused, then the jurisdictions are in place to address it. Cameroon works with international instruments, including instruments working in the realm of torture, to fight torture, that is. Someone, I've already said this, and I'll say it again. This ratification came in 2010 with the protocol. And I don't want to go back to that sad event, but the documents were lost their way, but they will be completed and submitted. So we are in phase. Our domestic legislation is in step with international law, and the same for our institutions in all areas of law enforcement. The second observation that I wish to make, Mr. Chairman, honorable members of this committee, has to do with the crisis that is coming to an end, thank the Lord, as a result of the resolve from the head of state and international partners and the administration, including the and for this, the High Commissioner and for Human Rights and the United Nations have commended us. Perhaps I misunderstood. Someone said that this is a crisis between Anglophones and Francophones, and that's just false. That doesn't exist. Cameroon is one nation, and I say this stricto sensu. There are some citizens that have said, driven by whatever they're driven by, we don't need to open a debate about this, but they have said that they would like to succeed. However, but this political succession, we don't seek through killing, kidnapping, the burning down of facilities, schools, hospitals. It is the state role to deploy law enforcement to keep the peace and to protect the population. There's no war in Cameroon. There is no army fighting against our citizens. So I think that this is information that's worth noting. There are law enforcement efforts. They are responding to acts of terrorism. Those who have launched this movement are using means akin to those of terrorism. It's important to note this. Cameroon is a united country. It's important to note this, Mr. Chairman. We have more than 250 ethnic groups, and we live in peace and harmony. We are not divided by our cultures, by the English language, by the French language. We all speak English. We all speak French. To the contrary, this is a source of wealth for us, Mr. Chairman. So I think that these are very important items to note when we look at the case of Cameroon. I know that we're broadcasting live, and I know that the international community is listening to us. We must make it known that we are a democratic country with rule of law. Yes, people say all manner of things, and that's why people can put forth people can commit acts that are not sanctioned by the state, and then they will be punished for that. Having said that, Mr. Chairman, I could circle back to other items, but I think it's important to note that what I have just said and to do so with strength and clarity. Madam Director, many questions were asked of us yesterday. Perhaps you could circle back to some of those. I also will take the floor again now and then. Thank you very much, Madam Director. The floor is yours.
Thank you for giving me the floor. Many questions were asked yesterday, and we are going to present to the best of our ability responses to the questions that were asked. I'm going to start with issues related to domestic violence. Concerning domestic violence legislation, the process is underway. There's already a draft which is being reviewed by relevant stakeholders. And for the criminalization of marital rape, even though this is not yet a provision of the penal code, a spouse who has been a victim of rape can rely on the provisions of Section 296 of the penal code to seize the courts. The section provides, whoever by force or moral ascendancy compels anyone without, whether above or below the age of puberty, to have sexual intercourse with him shall be punished with imprisonment for from 5 to 10 years. So this is a provision of the penal code that a spouse can rely on in case of rape. As regards statistics on victims of violence, in 2022, 1,585 survivors of gender-based violence received care through the Ministry of Social Affairs. Furthermore, in 2023, the state, with the support of its partners, provided assistance in the context of monitoring GBV cases to 1,651 internally displaced women and girls from the Northwest and Southwest regions, amongst whom victims of sexual-based violence. This support consisted of counseling, material support, guidance, as well as the provision of dignitary kits. The number of persons concerned, there were 150 beneficiaries in Babaju, 171 in the town of Chang, 356 in Bafia, 176 in Ombesa, and 467 in Lum. With regard to the drafting of the national strategy to combat gender-based violence and the national action plan for the elimination of female genital mutilation mentioned in the state periodic report, the said documents have been completed. They were adopted in 2022. So we now have the National Strategy to Combat Gender-Based Violence 2022 to 2026, and the National Action Plan for the Elimination of Female Genital Mutilation 2022 to 2026. The main objective of the gender-based violence strategy is the reduction by 50% of gender-based violence cases by 2026. Yesterday, in listing some forms of gender-based violence against women in Cameroon, there was mention that abortion is outlawed in Cameroon. It is necessary to emphasize here that the ban on abortion is not a complete ban. Under Section 337, Sub 1 of the Penal Code, any woman procuring or consenting to her own abortion shall be punished with imprisonment for from 15 days to 1 year, or with fine of from 5,000 to 200,000 francs, or with both such imprisonment and fine. As per Section 337, Sub 2, whoever procures the abortion of a woman, notwithstanding her consent, shall be punished with imprisonment for from 1 to 5 years and with fine of from 100,000 to 200,000 francs, to 2 million francs rather. These sections notwithstanding, as I earlier said, the ban on abortion in Cameroon is not a complete ban. There are cases where abortion is authorized. These circumstances are provided for under Section 339 of the Penal Code. They are as follows. When abortion is performed by a qualified person and proved necessary for the saving of the mother from grave danger to her health. That's the first ground. The second exception is that abortion may be performed by a qualified medical practitioner in case of pregnancy resulting from rape. That is it as concerns the issues on domestic violence. Now I go to the issues that were raised, some of the issues that were raised around torture. As to the leniency of sentences and the fact that there is a time limit for the prosecution of the offense of torture. Here, it is necessary to recall that as per section 277, sub 3 of the Penal Code, sentences for torture are as follows. 1. Imprisonment from 10 to 20 years where torture causes a permanent deprivation of the use of all or part of a limb, organ, or sense. 2. Imprisonment from 5 to 10 years and a fine of 100,000 to 1 million francs where torture leads to illness or incapacity to work for more than 30 days. The third, imprisonment for from 2 to 5 years and with fine from 50,000 to 200,000 francs CFA where torture leads to illness or incapacity of no more than 30 days. The courts have rendered judgments with severe sentences in cases related to torture, which are mentioned in the state report. Another member of the delegation is going to come in to mention some new cases related to torture. And in conclusion, we are saying that the law is not static. Before Cameroon became a party to the Convention Against Torture, Inhuman or Degrading Treatment or Punishment in 1986, torture was not an offense in Cameroon. Following Cameroon's accession to the treaty, torture was criminalized by law number 97/009 of 10 January 1997, amending and supplementing certain provisions of the Penal Code. Thus, torture became an offense under Section 132 of the Penal Code. Following the amendment of the Penal Code in 2016, torture is now punishable under Section 277, sub 3, as I earlier mentioned. I will now move to the toll-free number that is run by the police, toll-free number 1500. Between the year 2022 and 2023, 179 human rights complaints were received through the toll-free number of the police 1500, which led to administrative and judicial investigations against the staff. Administrative sanctions ranged from blames to dismissal of employees from the police corps. The next issue that we are going to deal with is whether Decree number 2020/193 of 15 April 2020 to commute and remit sentences provided for the commutation of death sentences to life sentences for persons initially sentenced to death. The answer is yes. Under Article 1 of the said decree, persons who were sentenced to death were eligible for the death sentence to be commuted to life sentence. I'll now move to, there was a question raised on the accessibility of legal aid. Law number 2009/004 of 14 April 2019 to organize legal aid in Cameroon enables litigants who are not able to bear the cost of accessing justice to do so through waiver of court fees or the assignment of lawyers. There are legal aid commissions in various courts which grants legal aid all year round. Legal aid commissions are operational at all levels of the justice system. That is, at the courts of first instance, at the high courts, at the military tribunals, at the courts of appeal, and at the Supreme Court. By way of statistics, in 2023, out of the 222 applications for legal aid, 147 were granted. That is a rate of 66.21% compared to the rate in 2021 and 2022, when it was 54.94% of legal aid applications granted in 2021 and 44.75% of legal aid applications granted in 2022. So the granting of applications on legal aid has witnessed an increase. Furthermore, in criminal matters, as per the Criminal Procedure Code, a lawyer must be assigned as of right to accused persons standing trial for an offense punishable with a sentence of life imprisonment or with death. In the case of minors, as per Section 719 sub 2 of the Criminal Procedure Code, it is mandatory for the court to appoint counsel for a minor accused person who does not have one. Thus, counsel are systematically appointed by the court in such matters to represent accused persons. With regard to training, there was a question whether human rights training is mandatory for the recruitment of police into the public service. The answer is yes, human rights training is mandatory for recruitment of police officers and gendarme officers into the public service. How? Because during initial training of police officers and gendarme officers, they are bound to take a module on human rights that we've mentioned in the state report. So if you do not take that course on human rights, there is no way you are going to graduate from the police school or the gendarmerie school. Another issue was whether the prevention of torture was mandatory for continuous training. I would like to mention here that continuous training is carried out for the police, the gendarmerie, and penitentiary administration staff on the prevention of torture. Another issue that was raised was measures taken to make capacity building regular. In different ministries, measures are taken to ensure that staff are trained on human rights. If I take the example of the Ministry of Justice, every year in the budget of the Ministry of Justice, there is an amount earmarked for training on human rights. And a lot of those trainings have been carried out, be it on torture, on deprivation of liberty, and on many other topics that I would cite later. So there we have something that comes up every year. So in the budget of the Ministry of Justice, every year we have such trainings on human rights. And it does not end there. We also have partnerships with international organizations that come in to assist the government in providing human rights training. I may want to cite here the United Nations Office of the High Commissioner for Human Rights, represented in Cameroon. There is UNICEF as far as children's rights are concerned, and there are other agencies that come in to enable the government to fulfill this obligation. Coming back to the issue of continuous training for the police and the gendarmerie, it is important to note here that there is an institution known as IFOS, which stands for the International School of Security Forces, which is meant for the continuous training of police, gendarmes, and other officers. And those trained at these institutions are not only national staff, but this institution receives candidates from other countries in the sub-African region. I would like to end this part on training by giving some statistics. With regard to human rights generally, the Ministry of Justice in 2022 organized 19 workshops and trained 211 judicial and legal officers. This figure is compared to 161 persons who were trained in 2022 by the Ministry of Justice on Human Rights, and 125 who were trained in 2021. That is the number as far as judicial and legal officers are concerned. As far as other legal staff are concerned, 32 registrars were trained on human rights in 2023. 20 bailiffs were trained. And as I earlier said, the subject matters of training varies. We have domestic violence, we have criminal justice in general, we have child protection in the criminal justice system, we have protection of witnesses and victims, we have human rights in relation to health, and we have protection against torture. So those are some of the issues that were treated during workshops organized by the Ministry of Justice. Coming to the earlier on, I said different administrations are taking measures to train their staff. Here, I would like to mention that the Secretariat of State in charge of the National Gendarmerie in 2023 trained 1,100 staff members. That was, here we are talking of continuous training. Mr. Chair, I think I'll end there for the time being.
Okay. I think we still have Okay, with your permission, Mr. Chair, let me now give the floor to one member of our delegation, Judge Patrick. Patrick, you have the floor. Patrick,
Thank you, Your Excellencies. Thank you, Your Excellencies. Good afternoon, Mr. Chair, Mr. Vice Chair, Mr. Special Rapporteur, Mrs., and the other member of the committee. Des questions nous ont été posées hier.
There were questions yesterday on treatment of detainees and whether there were medical registers in places of temporary detention, gendarmerie and police facilities, and how those measures guaranteed health care for detainees. Now, the budget for food for detainees is constantly increasing from 2 billion CFA francs in 2016 to 3 billion in 2017, and then to some 5 billion in 2018, and a further increase in 2019. So the rise is 45%. This has made it possible to increase detainees' daily food ration. Furthermore, the government allows families to provide support to detainees as well. For the well-being of detainees, each prison has a nursing station, a pharmacy, and a laboratory. Serious cases are taken to hospitals, which have somewhat wider technical possibilities, and the budget for that in 2017 was 150 million CFA francs for medical care. And that was for 30,000 detainees. In 2018, it went up to slightly over 1.5 million CFA francs for 38,000 detainees. It remained constant in 2019. In 2020, it didn't change. It was 1.15 billion CFA francs. The total number of staff in the healthcare system for the prisoners was 273. And in 2020, it was 272. In 2019, there were 65,000 routine healthcare operations carried out on 1,004, and there were 1,400 cases that went to external consultation, with some 400 external operations. There were also some evacuations abroad. When people enter detention, they undergo a medical examination and a medical file is opened on them. That makes it possible to detect presumed cases of torture or ill treatment. And should that happen, then that person is sent back to the court for an investigation. And so the medical examination was also important in the fight against COVID, making it possible for the prison authorities to restrict the spread of COVID in prisons. On reports on deaths in custody, these are drawn up by the prison registrar and transmitted to the ministry via the prosecutor. Autopsies can be carried out where there is a suspicious death. Violence or negligence in prison have not been registered. On overcrowding, Cameroon, as we have mentioned, has 76 functional prisons and no secret prisons. From 32,000, almost 33,000 detainees in 2022. It's gone up to 35,500 in 2023. So a rise of 2,400 detainees. The prisons can hold 20,900 prisoners. In 2021, that was the case against 19,000 in 2022. To increase the capacity of the prisons, there is building underway and extension of existing prisons. There's been the Douala and Ngoma prison built with some 2,000 places, and the central prisons of Douala and Yaoundé have been extended. The secondary prisons of Dukula, Tum, and Banga, and the main prisons of Chibaki, Abambang, Kumba, Tolere, Lukaduma, Valmayo, Toledo, Monatele Ambam, Bandante, and Battery have undergone building work. On the population, in 2023, there were 49% of detainees registered and 51% had been sentenced. The first figure was for pretrial detention. As regards to the implementation of the improvement of the prisons policy, whose budgets have been increased from 20 billion CFA in 2018 to 22.7 billion in 2023, the government has increased the resources for prisons and for preparation of detainees for reintegration, and over 700 detainees were reintegrated from 2019 to 2022. They went to the prison administration school. A number received human rights training. So that's over 700 prisoners, as I mentioned. On torture cases under the review over the reporting period, the courts registered 44 cases relating to torture where rulings were handed down. The decisions are contained in the report. The ruling in the case where from 15 to 16 September 2021, there was a suspected thief who was inhumanly treated in police custody in Yaoundé. That was filmed and placed on social networks by the perpetrator of the complaint. The perpetrators of the abuse were arrested and brought to the Court of First Instance of Yaoundé and sentenced to imprisonment from 1 to 3 months. On rapid and impartial investigation for the protection of victims. On the case of Arsène Salomon Bani Zogo, also known as Martinez Zogo, the radio journalist on Amplitude FM. He was kidnapped in January 2023 by not unidentified individuals and taken to an unknown location, and his body was found on 22nd of January by residents outside Yaoundé. There was an investigation. Suspects were arrested and brought to the military court of Yaoundé to be charged. And this was under torture, for torture, killing, and abuse of function. These were the charges. So the procedure is underway under the jurisdiction of that court. The delays in the procedure are not because the state or the court system does not wish it to be sped up, but the defense is making arguments to which the court has to reply, and that can lead to a number of rounds of communication. There are investigations underway for another kidnapping. On the case of Longue, this involved military personnel, and there was an inquiry by the Defense Ministry so that the perpetrators could be identified and brought to book, as can be seen from the communication 2407 of October 2024 from the Defense Ministry. In other words, the investigation is underway in connection with the recommendations of the Cameroon Human Rights Commission. When the investigations reach their end, the suspects will then be brought to court. On the Seka Abassi case, that was in June 2018 in the Jiang department. He was trying to escape arrest and was killed. The gendarmerie commander there had shot him in the leg. He was taken to the military hospital where he died in July, 18th July 2018. The preliminary investigations were opened, unfortunately, on 13th November 2019. The presumed perpetrator died in Yaoundé Military Hospital while the investigation was still underway. And under Article 62 of the CPC, therefore the case had to be closed, given that the presumed perpetrator had died. However, the family members under Cameroon law can bring action of a civil nature. As to Chen Chilera, who died in August 2018 in Kumba prison, the autopsy found that he died following hypoglycemia. On the investigation and sanctions of the presumed perpetrators of abuse in the fight against Boko Haram, the ambassador mentioned that there is no use of torture in Cameroon. There was a circular letter from the Ministry of Defense, letter 19025, 2556 MINDEF 01 of 18th January 2019 to all defence and security services under his authority, he recalled the obligation to respect the right to life and to be treated with dignity. The circular was then also republished in Note 00153/MRP GN 244 of 28th January 2019. The Secretary of State for Defence, responsible for the gendarmerie, was the signatory of that, and this reiterated the instruction from the Defence Ministry and stated that torture was formally prohibited in Cameroon under the criminal code, and anybody who carried out torture as the perpetrator or authorizing or as an accomplice would be held accountable. The Yaoundé Military Court in September 2020 on the Elevet case, which was on the killing of 2 women and 2 children in Zelevet in Maya Moscouda region in 2015. Here, the perpetrators were sentenced to between 2 and 10 years of prison. The Public Prosecutor's Office appealed because it found the sentence too weak, and the procedure is underway in the appeals court. There have also been cases of inhuman treatment, the Ngarbu massacre case. Here, this was in the Northwest region. In February 2022, when the security forces, together with the militia members, attacked separatists, or responded rather to a separatist attack in the Gabu region. And during that operation, non-combatant civilians, including 3 women and 10 children, died in the crossfire. The presidential inquiry established 3 perpetrators brought to the military court of Yaoundé, and the procedure is still underway. In this procedure, as I mentioned before, the delays are due to respect for procedure. The military court judges crimes using 1 judge and 2 military advisors. And since both are present, this can lead to different rounds of communication and procedural incidents which can lead to delay. Excellencies, that brings me to the end of my comments.
Monsieur Patrick Belombe.
Thank you, Patrick Belombe. Mr. Chairman, with what has just been reported by Mr. Patrick Belombe and Ms. Attabong, this information supports a preliminary statement to the effect that we are a law-abiding state where torture is not a state practice. The head of state in person is vigorously combating any torture-related practices. I believe we have just illustrated this through certain high-profile cases which are regularly taken up by the press. International opinion, I believe, needs to take account of this. These are not state-related torture cases. These are isolated acts which are now being investigated by the justice system. I would like to come back to a number of items which I believe are important. Well, on refugees, as mentioned yesterday, in Cameroon, hosting of refugees is based on equal treatment. There is no discrimination. Our country does not discriminate between nationals and refugees. So I spoke of the assimilation policy yesterday. Assimilation in terms of consideration and treatment. And for example, looking at social rights, school, health. Refugee children and refugees themselves can be taken, can be treated by the health system and the education system on an equal footing with nationals, in keeping with our national law, which contains constitutional principles for the respect of human dignity based on the philosophy that we have in our country regarding human dignity. On refugees, again, we spoke of the complaints mechanism. And here, what I would say is that where there are cases, suspected cases, there's a procedure. UNHCR and our state have a procedure for dealing with complaints which are reviewed by the authorities. So refugees are protected by the law, both international law and Cameroonian law. Coming back to training, my colleagues emphasize training because this is the basis for respect for human rights. In 3 segments of human rights, respect, protection, promotion. Training is at the heart of this. Human rights courses and courses in humanitarian law, because these are 2 separate things, they are taught in most of our professional establishments. I was head of the International Relations Institution, and I was responsible for courses of that kind and even taught some. We've heard about a master's degree, which is based largely on human rights and humanitarian law. The 2 modules overlap to some degree because it's on, they both cover individual integrity and respect for human dignity. Our country is in every way endeavoring to respect human rights, protect them, provide global protection for individuals, and promote human rights in a preventive sense. I should also touch upon, again, this is connected with training, touch upon the key nature of this training. It's not just for law enforcement, it's for everybody. In terms of prevention and human rights, our legislation is flexible on associations. We have a large number of NGOs. I know that there are some in this room. There are many of them. They came here and gave their account of the human rights situation in Cameroon. And this is all part of our human rights landscape in Cameroon. I don't want to say that everything is perfect, but the commitment of our government and head of state is that human rights policy must be a pillar of state governance. Madam Director, I think you wanted to add something. And then I will make a concluding statement. I know that we still have about 30 minutes. I have a concluding statement, but I wonder whether you would like to take the floor first, Madam Director. So do please go ahead.
Thank you. Yesterday, there was a question on whether an action for habeas corpus can be filed before the military tribunal. The answer is no. But this does not mean that an accused person who is under the jurisdiction of the military tribunal cannot file an action for habeas corpus. Yesterday, I said the Criminal Procedure Code guides criminal prosecution both in the civilian and military courts. And under Section 584 of the Criminal Procedure Code, which deals with habeas corpus, anyone who is detained or arrested illegally can bring an action before the High Court to be released. And I would like to read Section 584 of the said Criminal Procedure Code. Section 584, sub 1. The president of the High Court of the place of arrest or detention of a person or any other judge of the said court shall have jurisdiction to hear applications for immediate release based on grounds of illegality of arrest or detention or failure to observe the formalities as provided by law. Section 584 sub 1, sub 3 rather, the application shall be filed either by the person arrested or detained or on his behalf by anyone else. Such application shall be unstamped. So that is it for Section 584, which does not limit the application of habeas corpus to those who are under the jurisdiction of civilian courts. So persons under the jurisdiction of civilian courts as well as under the jurisdiction of military tribunals can apply for habeas corpus. And while during my first presentation, I gave some statistics, and Mr. Chair, okay. I would like to end there.
Okay, thank you, Madam Director. Mr. Chair, we know that we still have 30 minutes. You want something to add? Okay, go on, Patrick.
Merci, Excellence.
Thank you, Your Excellency. There was a question that was asked yesterday by Mr. Contesse. It had to do with it had to do with evidence extracted under duress, under torture, and one needs to understand the Cameroonese procedural code or penal code rather to understand all the subtleties of this topic. Yes, indeed, Article 315 in the Criminal Procedural Code sets forth that, and I quote, confession is not admitted as evidence if it was obtained under duress, violence, or threat, or the promise of an advantage or benefit, or through any other way that might undermine the free will of the individual, end of quote. So what that means is that confessions obtained by coercion, duress, or any other means such as these that go beyond the mere will of the individual are set aside. In order to understand this, one really needs to combine one's reading of that document, of the criminal Article 315, with Article 122, line 2 of the same criminal procedural code, and Article 4 as well. Article 122, I was saying this yesterday when I was talking about being held in remand. This prevents bans the use of torture in all forms. That's included in the procedure. Now, there's an article that sanctions the violation of a procedural rule. Given that a preliminary inquiry or investigation is covered by the regulations of the criminal procedure, when we combine the reading of these, all statements that might be made under coercion are not admissible. So now the question is, how is it that a victim, how does a victim prove that they have been coerced in some way? And we have another code that reflects this under Article 309, addressing evidence. We see that there can be photos as evidence, there can be witnesses, all their means of evidence are admissible. And it's for that reason that today, for example, many inquiries or investigations are conducted through a wide array of different forms of evidence. However, to whom is it incumbent, who has the burden of the proof? Article 307 from the Criminal Procedural Code, we see that the burden of proof is upon the individual that puts into action a public prosecution, generally the prosecutor's office, or it can be a civil party as well. When someone goes before a court with a complaint as a civil party or the public ministry, but when a civil party comes, the public prosecutor's party is no longer the bringing the case. So again, the burden of the proof will change then if it's a civil party or private party. If we look at Article 309, in analyzing this, we see that when there is an allegation of facts, that text needs to be borne in mind. Head of delegation, I thank you for the time. The interpreter would note that the microphone was off for the head of delegation.
Okay, merci. Sure.
Microphone, please.
Voilà.
Very well, microphone is on. Thank you very much, Mr. Chairman. I know that we still have 30 minutes. I'm trying to manage time correctly, and we will have concluding remarks. I know that we haven't exhausted all of the responses. We have self-censored. We have limited what we've said because, by being so concise, we've perhaps left some matters out. I know that there might be other questions to ask. Perhaps after that, we can take the floor in order to be able to offer concluding remarks. Actually, you still have 2 hours, Mr. Ambassador. You still have 2 hours, Mr. Ambassador. And I will give the floor first to the rapporteurs and other members of the committee that might have additional questions to ask at this time. Madam Raku has the floor.
Thank you, Chair. Once again, welcome to our committee, distinguished member of the delegation. Welcome to the second round of dialogue. I would like to thank you for the replies and data provided to the committee. And I would like to express my gratitude that for some of our questions you have provided relevant additional information, explanation. For other less so, but I hope that you will make use of the opportunity to send additional information in writing, especially when it comes to statistical data. We understand it's a big country, 79 correctional facilities, plus police detention units and dozens of detention units under the National Gendarmerie. I listened carefully to your replies, and there are several areas which have been discussed during our first round of dialogue, but there are also some additional questions that need to be discussed with you today. And I will start with the issue of gender-based violence and harmful practices. Thank you for the update on the progress made in the field of gender-based violence prevention, and also on the update on the measure of support provided to the victims and survivors. But I really hope that following this dialogue, you will speed up the process, the legislative process, in order to criminalize certain type of offenses and certain type of violence against women, including domestic violence, which represent an imperative need in your country, given the high number of cases of domestic violence, and that you will redouble your efforts in prevention of harmful practices that still exist in some of the region of the country. Since torture and ill-treatment require a comprehensive approach, and I'm referring particularly to actions to prevent, combat, protect, and rehabilitate victims and survivors, but also I'm referring to one specific action, such as delivering of the capacity building activity to law enforcement, including judges and prosecutors in the areas related to our convention. I would appreciate your information regarding or more detailed information regarding protective measures, including availability of shelters and availability of rehabilitation services offered to victims and survivors of gender-based violence, trafficking in persons, but and other forms of violence against women, children, and elderly as well. I also have some additional questions regarding access to medical care in the police detention units. Maybe I have missed something, but still it's not very clear to me how the medical examination per se takes place after admission in a police detention unit or under the gendarmerie unit. I haven't heard your reply, but I hope I received some information in writing about the process of documenting and reporting cases or where people show certain injuries on admission to police detention or prison detention. Maybe you could tell us what are the legal provisions or internal regulations to report cases of possible torture and ill-treatment, because there is in vast majority of member states there is an obligation under national law to report such cases, and it's a positive obligation. It's mandatory not only for the medical personnel, but for the prison administration as well, to report such cases to local or national prosecutors, to Office of Human Rights Commissioner or Ombudsman. And we want to receive more detailed information in this respect, including if there are any specific internal records or registers on injuries and trauma in the police and gendarmerie detention facilities. In other words, how and to whom cases of injuries and possible cases of torture are reported. Also, we want to receive information on the number of suicides. We want to receive information on morbidity and mortality rate during police detention. You mentioned some services provided to those in you mentioned some information about the medical services provided to those under the correctional facilities, but did not provide sufficient information about access to medical service, including medication, for those under police detention. There is another important topic that I would like to draw your attention to, and it refers to the situation on the level of staff in correctional facilities, including medical personnel. If you could provide us figures, it would help us to assess objectively the situation concerning the access to medical care and medical services within prison facilities. Now I would like to turn to a particular question. It refers to juvenile justice and to juveniles in detention. There are no separate justice system for juveniles in Cameroon, and many child offenders are held together with adult prisoners. We have come across some reports indicating that there is a problem in separation between juveniles and adults. In Cameroon, there are specific legal provisions that address criminal responsibility of minors. And if I'm not mistaken, it's Section 80 of the Criminal Code that provides that minors between the ages of 10 and 14 may be subject to only one of the special measures provided for by law. And therefore, the judges are required to choose just one measure from a range of possible options, which usually include rehabilitation or imprisonment. Indeed, a minor over 14 and under 18 years old who is criminally responsible benefits from the mitigation procedure. That's the usual practice. But this means that the young offender should face sentences pursuing educational purposes, such as counseling, vocational training, community service, and other programs aimed at rehabilitation of young offenders. However, punitive measures for minors may include sentences such as imprisonment or fines that are designed to punish the minor for their criminal behavior rather than solely to educate and rehabilitate them. In theory, it looks fine. I mean, you have such alternatives in your criminal legislation, but in practice, unfortunately, punitive sanctions are the one that are most applied to juveniles. Another particular concern for our committee is that juvenile offenders rarely get legal representation and assistance, and often spend a long time in pretrial detention because prosecution attorneys do not prioritize their cases, and many of them are imprisoned in as I mentioned, in cells alongside with adults and in appalling material conditions. In this respect, I would like to ask you about measures that have been implemented by your government in order to set up system for a justice system for children based on the principle of restorative justice, prevention of juvenile delinquency, and social cohesion. Also, please explain us how the prison administration, police headquarters, as well as high-level management of the gendarmerie are ensuring that juveniles are separated from adults and that regular inspection are carried out to the places of detention accommodating children. Also, it's not clear to us whether civil society organizations, in particular human rights organizations, have full access to places of detention and prison to provide urgent direct assistance, medical, psychosocial, and educational support to juvenile offenders. Another problematic area, actually it's a great concern for our committee, is that armed groups such as vigilante groups or Boko Haram continue to recruit and use child soldiers, including girls, in attacks on civilian and military targets, and that some of the at least some of the separatists in the southwest, west, and northwest regions recruit and use child soldiers in combat roles and to gather intelligence, according to some human rights report. In this respect, we would like to ask you what measures have been taken to prevent the recruitment of children into these armed groups, and if you can provide us with relevant figures and qualitative information on efforts to combat this phenomena, it would be useful for us to assess the situation in an objective manner. I also have some question regarding psychiatric institutions. As I have learned, Cameroon has few government-run mental health facilities, especially the bigger one are Jamot Yaoundé and Lakitini in Douala. The current situation is that the mental health units in the regional hospitals are not functional due to the lack of specialized staff. I mean, it's not a particular problem that exists only in Cameroon. There is a persistent need in psychiatric specialists in many countries. What strikes me is that traditional practitioners, pastors and priests are trying to fill this gap and are treating mental health patients, and often to no avail. So you did not provide any relevant information into the state party report on psychiatric institution, as well as on residential centers, including social care homes, elderly homes, orphanages, and so on. And I would like to take this opportunity to discuss with you the situation in this institution, and namely, what are the procedures, conditions, and restraints. We want to be informed about authorities or state institutions that are able to carry out inspections and monitoring visits to psychiatric institutions and residential centers. And what are the measures you plan to take in order to improve the material conditions in this institution, including recruitment of necessary nurses and psychiatric specialists? And also, we want to receive information about the complaint mechanism that is available for persons with psychosocial disabilities in this type of institutions. And I think I will stop here, and we will be waiting for your replies, whether today or in writing after the dialogue. Thank you very much.
Gracias.
Thank you, Madam Raku. To continue with this interactive dialogue, I would like to give the floor at this time to Mr. Jorge Contese.
Muchas gracias, señor presidente.
Thank you very much, Mr. Chairman. And thank you very much to the delegation as well. I would like to thank you anew. I should like to begin, if I might, with something that the ambassador said. And I thank you for the information. It's very detailed. You had said that the state does not order anyone to practice torture. But the state is responsible not just of the actions of its civil servants, but also by their missions. So someone has the right to intervene and just not do so. That is say that is compelled to act under international standards. There were two things that were said yesterday to attack. The ambassador said that this is the first time that I've heard the word used, charnier used here, and I did a search on Google. 7 August, mass grave found with 2021 kidnapped victims. And then in 22, civilians bury finders in mass graves after military raids. The committee is not accusing anyone of being responsible here. But it is clear that these mass graves were reported by the media. And if this is false reporting, it'd be good to know. And if what's been reported is accurate, then it would be incumbent upon the state to investigate this and to determine responsibility and to punish those responsible. This is something that the committee notes in paragraph 25 of the list of issues. It's something that we do need to know whether it's true. And if it was investigated, what were the results of that? I will switch now.
A couple of things that Madame Atabon mentioned yesterday. And thank you very much for this also very detailed information. On military jurisdiction, I don't quite understand. It's very clear how you explain the situation of habeas corpus. I appreciate that. But I think the committee is still concerned that Madame Atabong said yesterday, military courts, military jurisdiction is not an exceptional court, it's a special jurisdiction, which is precisely what is said in the State Party report in paragraph 48. And you said there is no binding international treaty that prohibits military jurisdiction. But there are many human rights standards that, pursuant to which military jurisdiction, military courts should not try civilians. The Human Rights Committee, just to name a few, Human Rights Committee General Comment 32, 2007, trials of civilians by military or special courts should be exceptional. Human Rights Committee concluding observations of Egypt, 1993, 2002, the Russian Federation, 1995, Kuwait, 2000, Slovakia, 1997. 1999, the Human Rights Committee on Cameroon expressed concern about, quote, the jurisdiction of military courts over civilians and about the extension of that jurisdiction to offenses which are not per se of a military nature. For example, all offenses involving firearms, end of quote. This is precisely what the Committee Against Torture said yesterday in the first part of our dialogue. Concluding observations on Lebanon, Morocco, Syria, Poland, Nigeria, Peru, just to name a few. This committee, concluding observations of Peru, 1999, Jordan, 1995, Chile, 1995 as well. Standards by the European Court of Human Rights, the Inter-American Court of Human Rights, the African Commission on Human and People's Rights. In 1999, the Commission adopted the Declaration and Recommendations on the Right to a Fair Trial in Africa. I will read very briefly section L, A, and C. Quote, the only purpose of military courts shall be to determine offenses of a purely military nature, committed by military personnel, and they should not in any circumstances whatsoever have jurisdiction over civilians. There are a number of communications decided by the Commission, including one on Cameroon in 1997. All of this is to ask the very simple question is, why is it that if civilians, as the delegation has said, if civilians enjoy the same guarantees as when tried before a civilian court or a military court, why is it that Cameroon understands that many of the crimes, the instances, the offenses, the infractions must be tried before military courts, despite the fact that a number of international human rights bodies, including in the context of Africa, have expressly said this should be exceptional. It seems to me that this is not exceptional here. I appreciate the information on and the very impressive explanation on how the Code of Penal Procedure works on Articles 315.2 and 122.2. It's very clear, and we appreciate this information. However, the state party provided only one case where evidence obtained under duress has been excluded. And so the question remains, and it would be very helpful to have more information on two issues. One is how does Cameroon monitor compliance with Article 15 of the convention? What are the exact mechanisms that courts use to make sure that no one is being subject to torture or to violence or to duress or to coercion, to use the language of Article 122? And the second question that was also posed yesterday is, if the admission of evidence obtained by torture or violence or coercion or duress constitute grounds for appeal in any judicial or administrative proceedings. Once again, if you could provide information, cases, that would be extremely helpful. There's something that I may have misheard, and I apologize in advance if this is the case. When talking about the case of Mr. Martinez-Zogo, I think I heard that the delay in this investigation, the suspects have been sent before the military tribunal in Yaoundé. They charge torture, murder. And I think I heard that the delay is not due to the state's sort of will, but to the effect of procedural mechanisms. If this is so, I'm confused, because of course, if this is something that's related to the procedural mechanisms, of course, that's the state functioning or misfunctioning, we would say. So I'd like to understand exactly what is it that is delaying that particular investigation, as it could shed some light of how those investigations are being carried out. a couple of other things, Mr. President, and I'll stop now so we can have an actual conversation, which I appreciate that we have more time. One is I like what Madame Atabong said, that law is not static. I agree with you. That before becoming a party to the convention in 1986, torture was not an offense in Cameroon. And then it has followed the standards of the convention. I think you mentioned that on the toll-free number, in 2022, between 2022 and 2023, there were 179 human rights complaints, which led to both administrative and judicial investigations against staff concerned, against law enforcement officers. That's what I think. That's what I think I heard you. And there have been administrative sanctions, but I don't think I heard how many. What is the exact number of sanctions that have been imposed following those human rights complaints that were received in 2022, 2023? And finally, my final point, and you may have said this, and my apologies also if you did and I did not hear it, on the optional protocol. To fully understand, it was signed in 2009, 2010, I believe Parliament acted. And what exactly it is that it's been 14 years and Cameroon is still not a party to the OPCAT. If you could provide more explanation of what's happening there, I would appreciate it. Thank you very much again.
Muchas gracias. Pregunto.
Thank you very much. Are there any other members of the committee wishing to take the floor? Mr. Bugvold, please.
Thank you, Mr. Chairman, and thank you to the delegation for all the information that you provided. I wanted to follow up on one part of the discussion yesterday about LGBTI issues. If I understood correctly, the delegation said that the penal code criminalizes sexual relations with a person of the same sex. So let me put that issue to the side for now. But that all persons in Cameroon enjoy the same protection against attacks on their physical and moral integrity. So if an LGBTI person is attacked, that person has a right of recourse to the courts, if I understood correctly. So my question is this: we have a group, LGBTI people, that for whatever reason are particularly vulnerable, including particularly vulnerable to attacks. And of course, if such a person is attacked, that person should have equal access to protection from the courts. But what would be useful for me to hear is about whether you agree that the state has an affirmative responsibility to protect especially vulnerable persons from suffering attacks in the first place, including by working to create conditions and a climate that makes such attacks less likely. And if you agree that the state has such a responsibility, if you could talk a bit about some of the things that the government has done, educational programs, public outreach, or anything else, to carry out this responsibility in the case of vulnerable LGBTI persons. So, so thank you. Thank you if you can provide that information.
Gracias.
Thank you. Is there any other member of the committee who wishes to take the floor? I believe that is not the case. So what I propose, Ambassador, is that we take a break of some 15 minutes to allow you to organize your replies, given that we'll then also, after the end of the meeting, have 48 hours to provide answers in writing. So we will suspend for approximately 15 minutes so that you can organize your replies to that last round of questions. Thank you.
Reanudamos nuestra
Let us resume this meeting, and I will once more give the floor to the ambassador to address the replies to the last round of comments this afternoon. Ambassador.
Merci beaucoup.
Thank you very much, Mr. Chairman. Distinguished members, I will start by expressing my great appreciation for your interest through your questions, your interest in the human rights situation in my country, with a focus on the question of torture. I have the privilege of starting as head of delegation. Now, we had from a number of honourable members a series of questions. I will start with Mr. Contessa's questions. And Mr. Contessa asked 3 questions, I believe, or possibly it was 2 in the first. He said that I had indicated this, that the state did not instruct anybody to carry out torture. Yes, I affirm that. There is no state torture in Cameroon. With a focus on the question of torture. I have the privilege of starting as head of delegation. Now, we had from a number of honourable members a series of questions. I will start with Mr. Contessa's questions. And Mr. Contessa asked 3 questions, I believe, or possibly it was 2 in the first. He said that I had indicated this, that the state did not instruct anybody to carry out torture. Yes, I affirm that. There is no state torture in Cameroon. The state, the government, the authorities have never mandated anybody to go and torture anyone. That I reaffirm. But I believe that your question is one that is theoretical and based in form on the responsibility of the state. the state is responsible for protecting people within the territory. Any act carried out in a state, the authorities will be asked, you as the authorities of this country, what do you know about it? So there is a duty. Now, the question here is whether everything that we're reporting has been carried out on state orders and whether the state has given orders to torture. Now, I do not deny, I'm not saying that there is no cases of torture in Cameroon. There are some cases, and even in the most developed countries throughout the world, there are cases of torture. But what I'm saying is that there is no state torture. The state has never ordered anybody to practice torture. Every time there is a case of torture, when investigations are carried out, then we seek to identify the perpetrators and bring them to accountability. Now, I share with you your vision in that respect. Second thing, you spoke of mass graves. We have discussed this to some extent. And you cited Google. I don't want to comment on Google. It's a large research engine, and who feeds in the data is questionable. I am not denying that everything, I'm not denying all of the content of Google, but this type of information is something that has to be reaffirmed by a state. We saw from the research that you had carried out, you said that in the Northwest there was a mass grave found in 2022. That information is something that we will investigate and come back to you later on that, because I have seen two cases, even in Google. Google indicates that there's a 1984 mass grave, which is connected with a military tribunal. The director stated that before 1986, torture cases were not registered as a crime, but that doesn't mean that there wasn't any protection. This question was also raised regarding the second case connected, I believe, with a hospital and abandoned bodies buried a very long time ago. The research was carried out later, it appears, and it was found that the data was not reliable. So these two questions, I think, overlap somewhat as regards state responsibility. I reaffirm, there is no state torture in Cameroon. And that is the guideline, the vision, the governance principle of our head of state. Protecting individuals and human dignity is a priority under our president. Where cases are proven, then individuals are brought to court. If we receive any additional information, I will transmit it to you. As you know, we will be able to submit some written information. I may come back to this question later since we still have some time, but first of all, I will give the floor to the director, and let us not forget that there will also be a concluding statement.
I'm going to start with domestic violence. As far as safe spaces for victims of domestic violence is concerned, the government, through the Ministry of Women's Empowerment and the Family, has put in place pilot shelters to receive women who are victims of domestic violence and to provide them care. So government is working to improve on these shelters. With regard to other kinds of harmful practices that were mentioned, particularly trafficking in persons, there is a center in Yaoundé which receives victims of illegal migration, amongst whom are victims of trafficking. So this center is in place, and the government is working hand in hand with the International Organization for Migration to provide care for these victims. This care includes psychological care and resettling them, giving them some resources that could help them start some business. Also, there is a toll-free number, 1503, where complaints concerning trafficking in persons can be lodged. So the number is 1503. Now I will move over to the issue of the measures which are being taken by government to make sure that a separate juvenile justice system is set up. At the Ministry of Justice, there is a project called the Juvenile Justice Project, which the government is executing with UNICEF. The aim of this project is to improve on the treatment of children in the justice system. And through this project, a lot of training is being carried out on the treatment of children in the justice system. That's children in conflict with the law, in contact with the law, be they accused persons, witnesses, or victims. So trainings are going on every year. Trainings are carried out to ensure that children in the justice system are treated better. In certain courts, with regard to criminal matters, there are certain magistrates who, I would not say they are specialized in the rights of the child, but in certain courts, cases concerning children are treated only by specific magistrates. So we can say they are developing some specialization in the handling of cases concerning children. Then with regard to separation of children from adults in police cells, generally they are separated, but sometimes there is a challenge because certain police cells may not have enough space when there are many detainees. That is why in certain police stations, you would see children sitting behind counters and not inside the cells because of that willingness to separate the children from the adults. So when there is not enough infrastructure, you will find those children sitting behind the desks in offices with police. So there was also this issue that priority is given to sentencing rather than rehabilitation of children. The speaker rightly said that there were provisions in the law that provided for specific treatment of children. If we look at the Criminal Procedure Code, you'll find a lot of those provisions. And one of them is that when it comes to sentencing children, instead of passing a sentence, the child may rather be sent to a rehabilitation center or a center meant for children. So the Ministry of Social Affairs has such centers, and there are children who have been sent to such centers instead of being sent to prison. Thank you.
Thank you, Madam Director. Mr. Director, you have something to add? Okay, please.
Thank you, Mr. Ambassador. Il y a des questions qui ont été...
There are questions that were asked on access to care for those that have been held in remand. When someone held in remand arrives in at a judicial police station, whether it's the gendarmerie or the police, if that individual has a particular affliction that requires the care of a doctor, the regional police units have healthcare centers, forensic healthcare centers. So that individual will be referred to those services or to hospitals. Hospitals that have, in some cases, they have more advanced equipment. And this is the same whether what it's military hospitals in the case of the gendarmerie or regular hospitals in the case of the judicial police. Now, the child recruitment in, for example, Boko Haram, non-state actors, armed actors, there has been an improvement in the security situation, and the threat has shifted. We have gone from attacks with IEDs. We've gone to, or moved away from IEDs. So the High Command has adapted its system. We are working with different bodies to address specifically the problem of the IEDs. For example, there's the Kinshasa region where there is a fight against small arms and light weapons and their use. Mr. Conteste is asking about the Martinez-Zogo case. I had explained one needs to be a specialist in Cameroonese criminal procedural code in order to fully understand the delays. And I can confirm again, this is not the state that's slowing it down, that's slow walking it. There are different aspects of the processes, the criminal aspect, and the procedures are more rigid there. We have to ensure that the parties involved have counsel. We have to ensure that they've been notified, that they will be brought before an investigative judge. We have to ensure that the case is put together prior to any discussion, that the case is properly put together. There are all these procedures that we need to have in place. I can assure you that each party is informed. Each party is informed. For example, if there are 20 parties to a dossier, then all 20 parties have to send in their list of witnesses. And of course, that's going to cause some problems in the back and forth. I had explained that there are also other scenarios that arise and that have to arise before any substantive discussion. The judges have to rule on motions that come about before the discussion in court opens. So what this means is that, in effect, on a given case that will be brought into the legal system today, it might be in March or April that the debate is, or the hearing is fully open, because there are all these procedural steps that need to be respected. There's Article 4 of the Criminal Procedural Code as well, which sanctions violations of the code, of the provisions of the code. So perhaps that can explain how, on a procedural level, we have to operate. The law is clear on this and on how we need to proceed. Again, there has to be legal counsel. And in many cases, the judges have to rule on, the judge can appoint a court-appointed lawyer or counsel, which can be refused, and the judge has to do it again. So, Mr. Conteste, this is all before the case even fully opens. Before the process, the prosecution really fully opens, all parties have to be called in, and this takes some time. We don't have the European system that allows for immediate communication by internet. For example, the communication is on an individual basis. And when the case then moves ahead, the prosecutor might call in witnesses. And if there are 10 witnesses, well, there needs to be 10 different, then there are 10 individuals that that will be meeting with the prosecutor, but then in the case of a civil party, also parties of the defense. Those who are not, as I have said, familiar with the Cameroonese criminal procedural code, won't understand necessarily that this means that our system is to make sure that everyone is heard. We are respecting the principle of principles of an adversarial system where people can come before each other. That's what I want to offer as information on this specific case, the Martinez-Zogo case. Now, confessions. I had said confessions obtained under duress or by coercion, moral, physical torture, they're all inadmissible. There is one case that was noted or that was mentioned, and we can look deeper into it before putting forth a position on that. But my experience has been, because I was on the ground, and in my experience, the procedures, the criminal procedures, sometimes show that maybe one individual, when it is shown that someone was tortured, then the case is thrown out. However, if there's a case that goes to appeal, that it's not a new case. The case goes up to the appeals court, and the appeals court is only going to be ruling on the points that were addressed in the court with the first level trial judge. And there's no opportunity to ask for the admission of new evidence. So if the confession under torture was not admitted in the first level trial case, then it won't be admitted under appeals. So there, if I might, is what I can add at this time, Mr. Ambassador. Thank you very much. Thank you. There was another question on LGBTI, on the LGBTI community. I think that we simply need to note that in Cameroon, as in many countries, individuals, whoever they may be, whatever their nature might be, are protected. There's no targeting of the LGBTI community. I have to recognize, and I think that we've seen this in other legal systems. In Cameroon, the practice of homosexuality is not it's banned. It's not in step with our mores. And should there be a flagrant display thereof, that means what? If someone says that a police officer says we can't arrest that person unless that person is caught in flagrant, rather red-handed, if you will, en flagrant délit, committing acts of homosexuality. Now, if there's something, if there's something that's illicit and the NGOs support that illicit act, then it is a manifesto in favor of that act. Those that are responsible for the criminal procedure in a country and the moral well-being of its citizens understand this quite well. All individuals are protected, LGBTI or no, as long as it has not been established that they have committed a crime. There's no targeting, no profiling, no attacks, as some have said. There's a great deal of literature indicating that we assassinate, that we kill homosexuals. This doesn't happen in Cameroon. But the practice of homosexuality is banned in Cameroon. I can have my legal experts here add more. I'm not sure whether I've expressed this correctly, but in my with my legal background, that is what I understand. These are the three questions that we received. Of course, we would like to have our closing remarks when appropriate. That, of course, is in your hands, Mr. Chairman. If there are other questions, we can respond to them. Thank you very much. I'd like to ask members of the committee if at this time they would like to offer comments. Mr. Rwan, the floor is yours. Thank you very much, Mr. Chairman. I would merely like to make a brief comment. I don't have questions to ask. My question has to do with the state's responsibility vis-a-vis the convention or under the convention. I'd like to repeat what my colleague, Mr. Tusmus-Komadov, has mentioned. We are not a court, we're not a tribunal, we are not trying the states. But we have been called upon by the states to supervise their implementation of the commitments they have undertaken themselves by joining the convention. So I would like to circle back to Article 2 of the convention. It is incumbent upon states to take all measures necessary, administratively, judicially, or in other regards, in order to prevent, punish, and prevent torture. So, Mr. Ambassador, with all due respect, the general commands, the concluding observations of the committee rectifies the speaker, have their jurisprudence. Even when there are acts that enter under Article 16, we still have Article 1 of the Convention which defines torture. There can be the matter of ill treatment as well. Even when such acts are conducted in the hands of a private body, the responsibility of the state is established. And that's where we're trying to point this dialogue, at that fact. It's an interactive dialogue, of course. The goal is to have a constructive dialogue to help you, to offer you succor. And of course, we like to mention the positive aspects, the successes, but the negative aspects as well. The idea being to assist you in the implementation of your obligations under the convention. I don't want to linger on this topic, but the responsibility is still there. It's the same responsibility even when private parties are responsible. I understand that you wish to explain that it's not a state policy in Cameroon, but the responsibility remains in the hands of the state and of all states that have ratified the convention. If necessary measures are not taken in the judiciary, on the administrative level, and in other ambits as well, to punish and prevent torture. I apologize for this brief intervention. Thank you. Thank you very much. Thank you, Mr. Wan, for your comment. And I would now like to ask if anyone else would like the floor. Mr. Kessing, the floor is yours.
Thank you very much, Chair, and thank you very much to the esteemed delegation. I just want to raise the issue which my colleague, Mr. Contessa, brought up earlier. I think it's a very relevant question, the use of military courts to prosecute civilians, which, as explained by Mr. Contessa, has been criticized by many human rights bodies. So I would very much appreciate if the state representative could give some more elaboration on their views of this, if it's normal to use to prosecute civilians in military courts, and what is your position with regard to the criticism by human rights bodies. I would appreciate that much. Thank you very much.
Thank you very much. Are there other comments at this time? Mr. Contessa, please.
Thank you, Mr. Chairman. It's good that we still have some time so we can actually have and continue the conversation with the delegation. I appreciate Mr. Kessing for reiterating the question of military courts and military jurisdiction that was not answered. I'm also missing an answer on the question of the optional protocol. To fully understand what's happening, it's been 14 years, and Cameroon has the chance to lead. The president of the General Assembly is from Cameroon, and that's a motive of celebration. Cameroon should be leading the way by fully ratifying and enforcing OPCAD. It has a Human Rights Commission, so it has a dedicated place that could be the National Preventive Mechanism. So we would like to fully understand what's happening with that delay. And two more things. One is, I didn't mean to say that I just found in Google. No, these are articles published in Voice of America, 29 April 2022, signed by a journalist, Moki Edwin Kinzeka. An article, same date, in News Central TV, signed by another journalist. And a third article that I just found in Cameroon Concord News, 11 November 2019, signed by two journalists. These are not anonymous sources. These are media sources. And so it's important that the state party be able to assess what's happening and investigate what is happening here. And final point. Voy a hablar en español.
I'm going to revert to Spanish. I understand the distinction that's being made. Again, I thank you for your clarity in explaining the distinction between correctional activities and criminal activities in the judicial system. And I'm not a specialist in Cameroonese law. And the delays have to do with ensuring that all of the parties are enjoying due process. That's something that is required of all states. All states. That is to say, all states that are party to the Convention Against Torture. What's key here is that the delegation of the state can inform the committee, can report to the committee, because the committee has asked for specific information on specific cases. And what are the results of those specific judicial investigations, and not in the abstract?
Entendiendo el artículo 4.
Understanding Article 4 of the Criminal Procedural Code, 315, no, not in the abstract. Paragraphs 11, 12, 19, and 20 of the concluding observations of the Fifth Periodic Review, or the Fifth Periodic Report. Paragraph 20. In the list of issues prior to reporting. In these texts, the committee requested specific information on specific victims with name and surname. It is in this context, in this dialogue, that we've talked about some high-profile cases. But what's really important here is really to look at what happens with cases of individuals that are not high-profile individuals, people that are not well-known. And the committee is not a tribunal. It could be that there's no order from the state to commit torture. We haven't said that there was, but we do have information of individuals that have been subjected to torture and ill treatment as defined by the convention, and that, hence, as explained by my colleague, Mr. Ruan, the state has a duty under the convention to undertake due diligence. And that's what we're asking about. What are the measures that the state of Cameroon is taking in order to ensure within the framework of due process that these investigations are conducted and concluded?
Como digo, para no decirlo acá.
So we have all the information here. In paragraph 20, in the yellow list of issues prior to reporting, we see the lists of names of individuals. And this is my last comment for right now. The ambassador said at the outset that there is no one that is more criticized than the president in Cameroon. That happens in any constitutional democracy. The authorities are exposed to a greater level of criticism, not less criticism. The source of concern of the committee is that in the cases that we discussed yesterday, what they all have in common, what the victims have in common, is that all of them criticized the administration in Cameroon. This isn't a trial here. That's in the hands of the state, but they are influencers, they are journalists, they're individuals that have used their platforms to criticize the administration. It could just be a mere coincidence, but if there's not due diligence, if there are not investigations looking into who is responsible for that, we don't have any way of knowing. I thank you, Mr. Chairman. I thank you. I would like to ask the ambassador if at this time he would like to respond to these, to this last round of questions that have been proffered by 3 members of the committee. You have the floor.
Señor Presidente.
Thank you, Chairman. Mr. Chairman, I think we have to respond to this constructive debate. Distinguished members, I must reassure you, we have the same state of mind. Mr. Wan, we know this is not a courtroom. We're here because you're helping us to improve our human rights governance. We're not losing sight of that. On state responsibility, yes. If we have authorities elected to take care of the country, then everything that happens in the country is something that they're accountable for. I represent them here. That's why I'm speaking. I was drawing a distinction. I think we understand each other. I said there was no state-mandated torture. It is not the state ordering the torture. And I agree with you. But I'm not denying that there is torture. There is some. Everything that you say, it is the state that must look into that. The state needs to make adequate efforts
Gracias.
Thank you, Ambassador. Before I give the floor for your concluding statement, which we're looking forward to, what I would like to point to is the richness of this exchange between the committee and the delegation. It has made it possible for us to see the acceptance of responsibility of the state for a series of trends, which to some degree are an obstacle to the application, the full application of all of the provisions of the convention, and which are problems which you as a state party must address in the future. I already mentioned the time frame of 48 hours that you have to provide additional information. On 21st November at 6 p.m., the Secretariat will send to the permanent mission the concluding observations. This is not for them to be revised, corrected. It's for details, if you will, dates and names of institutions. And then on the last day of our committee session, we will publicly be adopting the concluding observations. I simply wanted to point to what the committee looks for in concluding observations. It seeks to set out 3 or 4 recommendations which can be seen as priorities for the state to achieve within a year. And this dialogue, I believe, has made it possible for us to diagnose where the main problems or concerns are. And that is the constructive spirit in which the committee will be seeking to make recommendations, and we hope that this will be useful for you, as you say, within your commitment to human rights. We are interested, as we issue the recommendations, in a follow-up, ongoing, continuous dialogue between the committee and the state party. That is the goal. And we mentioned this repeatedly in the celebration this morning of the 40th anniversary of the Convention Against Torture. So we thank you, Mr. Ambassador, and your team for your readiness to listen to the concerns of the committee and receive our recommendations on the priorities to be addressed. And with that, I will give you the floor for your concluding statement.
Merci beaucoup, monsieur.
Thank you, Mr. Chairperson, and I thank the distinguished members. Mr. Chairperson, you have said everything, I believe. It is difficult to take the floor after words of wisdom. I agree with you that we have had a very constructive debate. We have learned a lot. On behalf of my delegation, I want warmly to thank you for the sustained attention with which you have reviewed our 6th periodic report and for the high quality of this dialogue that we have just had. This exchange has allowed us to provide clarifications on the progress made by Cameroon in guaranteeing respect for human rights, particularly in the fields of prevention and combating torture and inhuman treatment. Mr. Chair, distinguished members, your expertise and your questions will enrich our further consideration and legislative development. We see this as guidelines in pursuing the development of our national system to protect human rights. Under the guidance of our president, as I stated at the outset, since our president took office, he has made human rights a core part of his policy. We reaffirm our country's determination to pursue the necessary reforms to increase transparency, justice, and respect for the rights of all of our people and everybody living in our country. We spoke of refugees, migrants, and asylum seekers. In particular, we note the concern that you raised regarding detention conditions, protection of populations in regions of conflict, and measures effectively to ensure that the national prevention mechanism is effective. I should reiterate, and I know that the international community is following this because we're at the United Nations, the Northwest and Southwest conflict is not one based around language or region as such. It is a few separatists who have sought to secede using violence. Under the head of state's vision, we will continue to apply all necessary resources to strengthen respect for human rights, in particular in vulnerable areas like the one I have just mentioned. The policies that we have presented today reflect the government's firm determination to make progress in our country towards comprehensive respect for international commitments undertaken by our country, which we continue to undertake. Once more, I reiterate, we will be depositing the instrument of ratification of the optional protocol. We note the constructive comments made by yourselves and commit, as we always have, to work closely with the Committee Against Torture in order to meet the expectations of the international community on human rights. We, Mr. Chairman, will be broadly disseminating the recommendations to the administration and civil society, which is represented here in the room, in order that we may take ownership and effectively implement them. Cameroon remains firmly committed to all principles of international law and human rights, indivisibility of human rights. These rights are interdependent, equal, and self-reinforcing. In practice, it is clear that the order of priorities for implementation takes account of the economic situation of our states. In our context, these socioeconomic challenges and the criteria presented by the two rapporteurs, whom I thank for their exhaustive reports, these influence the action of the government without being a justification for delays. These, unfortunately, are factors that we have to call on you to consider in order to see the scope of the efforts made by our country despite the difficult situation. These efforts show that while there is still work to be done, Cameroon is resolutely moving towards practices fully in line with its international commitments. It looks forward to receiving any support from the committee and other United Nations mechanisms, as well as multilateral and bilateral partners within the respective national sovereignty, in order to build on our progress and strengthen our human rights development. In conclusion, I would like to reiterate Cameroon's readiness to maintain open, constructive dialogue with the Committee Against Torture and to remain a committed stakeholder working for human rights. This remains at the heart of the action of our head of state, Paul Biya, who continues to make protection of individuals, development and well-being of individuals a priority of our government. We thank all of you. We thank all of the members of the committee for their support for this important dialogue, where we have exchanged a lot of information. It's been very enriching. I thank you very much, Mr. Chairman. Thank you. Thank you, Ambassador. We welcome your words and the participation of your dialogue and look forward to ongoing communication. And with that, thank you very much. The meeting stands adjourned.